Welcome back. My name is Thomas Lundmark, and this is the last video of my tutorial on the features of common law and civil law systems. In this video, we'll be talking about the roles of lawyers and judges in resolving disputes. We'll start with looking at the judiciaries of a few jurisdictions, beginning with Germany. Germany has 5 separate court systems. The most important in terms of numbers are the courts of ordinary jurisdiction. These courts hear all criminal cases and all civil cases. Civil, in this sense, means all civil cases that do not fall within the jurisdiction of the labor courts, the social courts, the tax courts, or the administrative courts. Germany, in the civil law tradition, has a very large judiciary. There's one judge for every 4,000 people. Moving to England and Wales, the most important civil court is the county court. And here, civil means everything that is not criminal. The Crown Court handles the most serious criminal cases, including jury trials. England and Wales also have 28 tribunals. The most important of them are listed on the slide. I'd also like to mention the Magistrates' Court. The Magistrates' Court in England and Wales handles 95% of all petty offenses, and yet the vast majority of the judges are not trained judges at all. They are lay judges. They're called justices of the peace. In part due to the fact that England and Wales have a magistrates' court, they have a very small judiciary, at least compared to the civil law tradition. In England and Wales, there is only one judge for every 44,000 people. The United States has state courts and federal courts. Each state has its own court system, and the state courts handle easily 90% of all civil and criminal matters. The federal courts have jurisdiction over 2 areas of law. First, all federal law, questions of federal law, federal constitutional law, etc. The other head of jurisdiction is diversity of citizenship. That is in cases where all of the plaintiffs and all of the defendants are citizens or residents of different states or of different countries. There is one judge for every 35,000 people in the United States. This brings us to the topic judicial density. Civilian jurisdictions generally have many judges compared to common law jurisdictions. You can see on the slide that, let's take Germany, one judge for every 4,000 people, whereas in England and Wales, there's one judge for every 44,000 people. How can England and Wales get along with so few judges? Well, we've seen one reason. That is that they use lay judges who are not professional judges, and accordingly they're not counted. But I'd like to look at 2 other important reasons. One is the role of common lawyers out of court, and the other of common lawyers or common law lawyers in court. First, the role of common lawyers out of court. In common law jurisdictions, up to 97% of civil cases are resolved with little or no judicial involvement. That doesn't mean that they're all settled by the parties. There's other reasons that the judge does not have to be involved. But a very substantial amount of cases are resolved by settlement, alternative dispute resolution in its many forms. Settlement rates in civilian jurisdictions are much lower. In Germany, rates of settlement range between 15% to 25%, and judges must resolve all the remaining cases that are not dismissed for some other reason. Let's speak briefly about the role of common lawyers in court. Common lawyers present evidence. That means that they'll provide the writings, that is, documents and other things that the court, whether it's a judge or jury, will have to consider. And they will also call, that is, identify and bring into court all the witnesses and interrogate or question them in court. Judges need not know the law in the common law tradition, unlike the civilian tradition of jura novit curia. That means that sometimes, in the civil cases often, the lawyers will assist the judge in finding and applying the law. Let's look briefly at the role of a judge in civilian disputes. Civil law judges tend to be quite specialized. We saw that on the example of Germany. Often, there are multiple judges involved, sometimes even in the first instance. In such cases, the reporting judge will work up the case, will present the facts, and will explain the applicable law if necessary. The other judges will agree with the reporting judge unless they detect a miscarriage of justice, which is not often the case. In the common law tradition, the lawyers themselves tend to be quite specialized. The lawyers will work up the case, present the facts, explain the applicable law if necessary, and the judge will agree with one of the lawyers unless he or she detects a miscarriage of justice. And of course, appellate cases are decided by multiple judges, generally at least 3. This is at the core of this so-called difference between adversarial and inquisitorial systems. Even though I don't like the terms, we'll use them for now and look first at the civilian standpoint. From a civilian or civil law standpoint, one can criticize the common law tradition on the basis that common lawyers perform tasks which should be performed by the judge, such as choosing the witnesses, questioning the witnesses. From a common law standpoint, civilian judges exhibit partiality by taking over tasks usually performed by the trial lawyer, such as choosing and questioning witnesses. You can see that the roles of judges and lawyers overlap substantially. I recommend, if you're interested in reading further on this topic, reading my script for this lecture and also reading Chapter 5 of my book, Charting the Divide Between Common and Civil Law. Thank you very much.